Well, welcome to this Data Protection Network webinar today, where we're going to be answering your questions on what are the challenging issues in the world of data protection. And we have got a great panel, and I wonder if, Simon, you could, thank you.
Just pop the slides up, yeah. Pop
the slides up. So there's the panel for today. Myself, I'm Robert Bond. I'm Senior Counsel with Privacy Partnership Law in London. I also am Company Secretary and a trustee of the Southwest Grid for Learning that runs the Revenge Porn Hotline and the NCII initiative. And I know that some questions are going to be around children's data later on, so I flag up my interest. And our esteemed first panelist who will be doing a short presentation is Steve Wood. And Steve, would you like to say a few words to introduce yourself?
Yeah, thanks so much, Robert, and really pleased to be here, and thanks to DPN for the invitation. So yeah, I'm the founder and director of PrivacyX Consulting. We're an independent consulting firm. I've been established for about 2 years. A lot of people, though, will know me with my previous hat on. I worked for the ICO for about 15 years, and I was the Deputy Information Commissioner for the last 6 of those years. I was also the ICO's representative on the European Data Protection Board until Brexit, and I was also the chair of the OECD Working Party on Data Governance and Privacy as well.
Fabulous. And Eleanor, over to you.
Thank you so much, Robert. It's great to be here. Thank you for the invitation. My name's Eleanor Deuce. I'm a partner and head of data and privacy at Bates Wells, which is a law firm in the City of London, working on all aspects of data protection and compliance, including emerging technologies.
And...
Oh, can you hear me?
Yes, I can.
Oh, sorry. And just previously, I used to be a government lawyer, and I was the lead lawyer on the GDPR negotiations in Brussels.
Super, thank you. And finally, Simon.
Yes, well, first of all, it's great to have you all on board today. That's the audience and the panel, so thank you all. So I'm Simon Blanchard. I'm partner at DPN. Been with the business about 10 years now. So just for those who've not joined us before on one of the DPN webinars, we produce lots of kind of practical guidance, topical articles, and obviously we run events like this on data protection, privacy matters and security. So again, more details on our website if you'd like to find out any more about that. But in addition, we're also a consultancy and we do training as well for organisations across data protection. And we work with a large number of organisations, both small businesses, charities, and obviously some large corporates as well. So, helping them with their privacy programs and helping them kind of tackle emerging issues. So without further ado, I think probably best to hand over to Steve now, who's going to take us through the kind of main presentation, first of all, before we'll come back for some kind of questions and answers as well. Okay, so I'll pop on to the next slide, if that's okay, Steve.
Yeah, thanks so much, Simon. Yeah, I'm just going to talk for hopefully around 10 minutes to really, I think, set the scene, hopefully help get the conversation going, and to sort of talk about some of my experience of regulatory risks in the data protection sphere and what organizations should be learning from in terms of what data protection authorities are focused on, and what the emerging issues are that can help you plan ahead in terms of your data protection strategies. So I'm going to particularly talk about the UK, obviously, and I'll talk about the EU as well, and I will also talk about some global trends as well towards the end of the presentation. So if you want to move on to the next slide, Simon. The first thing I want to talk about is to highlight how regulatory risk can really transpire for your organizations in terms of how you can come under the spotlight of a data protection authority. And on the left-hand side there, I've got a list really of the range of different ways that data protection authorities can gather information and evidence. And I think this is to highlight and to stress as well that it's a whole range of different ways that data protection authorities can gather information about organizations, and also, I say, to monitor trends in sectors as well. So there's there's a significant number of different interaction points. So I think it's worth stressing here as well. I think data protection authorities, as they're learning to deal with the fast pace of technology, which is obviously, it accelerated, over the last 5 years, and even perhaps even quicker over the last 2 years with AI, they're considering a range of, reactive functions, which obviously they have in law in terms of handling complaints, etc., but also proactive measures in terms of how they're actually seeking information, monitoring what's happening with certain high-risk sectors, with certain groups of companies, and how that all then fits into the picture of information that they have about compliance. So it's worth noting of all of these different ways that your organization could come under the radar, particularly of a data protection authority, the ICO in the UK, or an EU data protection authority, and a number of data protection authorities globally will deploy these mechanisms as well. And I think it's worth noting, yet, as I said earlier, beyond the complaints and the data breach notifications, which are interactions you all know well, to think as well about the own motion inquiries that data protection regulators are initiating, where they can see a risk coming on the horizon, that they're stepping out and they're actually starting to look at particular issues when they can see perhaps evidence building up. Sometimes that can come from media coverage, sometimes it can come from the stakeholder engagement they've had about how they actually need to really start gathering a lot of information and data to decide where they should be sort of training their regulatory mechanisms in trying to actually therefore obviously uphold compliance with the law. So you've got a wide range of areas as well. And I think the last one as well, in terms of intelligence and aggregated reporting, is worth noting as well, because particularly the ICO is now investing in its own data strategy. So you may have seen now recently that the ICO has published its own enterprise data strategy, which is really how the ICO is sort of gearing up for the future, about how it's analyzing all of the data it's getting from breach notification, the data it's got from, over the years, hundreds of thousands of different complaints and investigations, and the intelligence it also gets from other forms of monitoring, about how it's actually got its own data strategy in terms of actually, drawing out pictures of, trends in terms of perhaps non-compliance or risks and issues developing in certain sectors or with certain companies as well. So I think it's worth noting that area is a particularly, new area that I think data protection authorities are going to need to start to invest in more. And I think that the key focus for data protection authorities at the moment is how can they sort of be agile in reacting to the environment they're regulating, whilst of course still dealing with some of the day in, day out issues that will always come across their desks, such as complaints about data subject access requests, etc. as well. So on the left-hand side, I've set out those are different ways that data protection authorities can gather information and evidence. And then again, on the other side, I sort of wanted to set out the full range of areas really where data protection authorities may take action, which can have an impact on you as an organization. So also trying to highlight the range of interactions which go beyond the areas that you obviously know best in terms of fines and enforcement notices. Reprimands obviously having greater prominence in the UK at the moment, because the ICO under the leadership of John Edwards is taking a far more proactive approach in terms of publicizing reprimands when the ICO is using them, and using them as an important tool in their regulatory focus. But thinking about different ways as well, where the interaction between you and the regulator could have an impact on the way you do data protection and the wider functioning of your organization or business. So also taking the first one as an example, in terms of, the interventions that a regulator can even make before you've launched something. Certainly for, major multinational tech companies, this is a significant issue. We saw that, just last week with Meta pausing their approach to using social media data in their generative AI training because of concerns raised by the Irish Data Protection Authority, working with the other EU data protection authorities, and also the UK ICO raised those concerns. So that was, an interaction where the regulator would raise their concerns, and the organisation obviously took those seriously and then actually paused what they were doing. So, there's an impact as well from advice and recommendations that organisations may receive. And there's a whole list of things as well, which may also play out in terms of how you may need to actually shape and change what you're doing on data protection because of the interaction with the regulator. particularly in terms of different forms of public reporting that the data protection authorities can undertake. The ICO as well will also issue formal opinions. Those opinions may not be directed to one particular company or organization, but the opinions may be directed towards a sector or a particular technology, but still could have a significant impact on how your organization is doing data protection. So one example would be obviously the opinions that the ICO is issued on facial recognition technology or on age assurance, and they will obviously continue to use that as a particular tool. And then the last one to note as well would be coordinated actions as well, in terms of how data protection authorities are also working with each other, so globally. So, there's information sharing between different data protection regulators who have, common interests. So we saw that very strongly in the investigations into Clearview AI, which, had multiple numbers of data protection authorities interacting with that company globally and coordinating their action. And obviously, we already have coordinated action right across the EU via the European Data Protection Board. And the ICO also has, many different memorandums of understanding internationally to share information, which is another form of impact that organizations can see if they come under investigation as well. So we'll move on to the next slide, Simon. I'm just going to sketch out a number of different areas that I think are perhaps the most important areas that we can see in terms of emerging data protection regulatory risks. So I've developed this list from learning about what data protection authorities are currently focused on in their activities and what they're planning to focus on. So what we can discern from their strategies and their forward plans as well. So just to really highlight the center of the document as well first, in terms of accountability as being the core component that perhaps binds all of these different risks together. And your accountability measures can get exposed, I would say, on an investigation in any of the other 8 areas we've got listed there. Because obviously accountability, will run right across the organization in terms of being the horizontal mechanism that you use to set out those actions and concrete controls to actually ensure you've got that effective implementation of data protection in your organization. And you're able to use your accountability program to demonstrate, the existence and the effectiveness of your actions and controls. And obviously you can use that to demonstrate to data protection authorities when they ask about it. And you can see that in a number of different cases as well. So just taking the UK as an example, we've seen in recent cases in relation to Serco, the facial recognition case recently, where there was an enforcement notice. The data protection impact assessment process played an important focus of how how Serco had gone about assessing their risks and compliance. We've seen it in the preliminary enforcement notice issued to Snap as well. So the key focus was on how Snap were assessing the risks. And also we saw it in a recent case where the Home Office were issued an enforcement notice by the ICO in terms of focusing on what they've done in terms of their policies and processes and governance, again, about assessing risk in relation to a scheme relating to migrants and also the tracking of migrants. So we can really see that data protection authorities are, always asking questions about, governance and mechanisms relating to accountability so they can understand whether the processing is compliant. And we know that a number of data protection authorities have also issued frameworks on accountability in terms of the ICO has a framework. There's one in Spain from the AAPD, the data protection authority there, and further afield as well, data protection and privacy authorities in Spain and Canada have produced them as well. So we've got accountability at the center here. And then just to move through the list fairly quickly, to highlight the ongoing importance of data governance and the importance of compliance with the core data protection principles that you all know and love as part of your day-to-day work, and obviously contained in Article 5 GDPR when we're thinking about the UK and the EU. There's still a range of cases coming out, month after month when you monitor what's happening in the EU in particular, in terms of actions DPAs are taking, whether it's storing customer data for excessive periods. So just to take one example, a case involving the CNIL levied €100,000 fine on a real estate provider society, PAP, where they had retention periods of over 10 years for contracts where the values were less than €120. So we can see a whole stream of cases where data protection authorities are still focusing on these these core elements in terms of the data governance and principles, and that's still a steady core important area of compliance. Next up as well is another foundational area. Data subject rights are still a cornerstone of data protection law in terms of how people want to access their data, because then they can understand how that data is being used, and it then allows them to exercise other rights. So data subject rights are still important. We're seeing a range of actions in the EU. EU data protection authorities are still often likely to take enforcement actions in individual cases where someone's rights haven't been upheld. So they may even issue a fine or issue an enforcement order. In those cases, the ICO is less likely to do that in individual cases. It more seeks to resolve them, but the ICO will look at what I would call systemic issues. So where there's long-standing issues with delays in responding to subject access requests or other rights requests, the ICO may step in and take action. We've seen some examples of that over recent years, including one public action where a reprimand was served on Virgin Media, for example. So a whole range of issues continue to come out on data subject rights. I think the other thing that's going to be worth noting is, particularly with the advent of AI and new technologies in terms of where individual concerns are arising as well, whether we're going to see a growth in data subject rights requests relating to rectification and deletion as well, whereas traditionally, obviously, the access request has been our bread and butter in the data protection sector. So I think that's an important area to note as well. And also as well, I think it's important to note that there are often issues sort of connected to data subject rights that come up in terms of whether an organization is asking for excessive amounts of identification to process a subject access request. So you can see some cases from the Irish Data Protection Commissioner relating to Airbnb in that area. And also we can see a case from the Netherlands in terms of Uber, in terms of the fine they received because they had an inaccessible process for data subjects to be able to execute their rights as well. So a whole host of issues will continue to develop around data subject rights. Also, marketing and ad tech is there. It's been a bit of a constant drumbeat for our sector. It's not going away anytime soon. In the UK as well, if you look through the list of enforcement actions from the ICO, they're still taking actions relating to non-compliant telephone marketing under the Privacy and Electronic Communications regulations, and also email and text marketing have still featured heavily over the last few years as well. And we also have a continued ongoing focus on ad tech. So I think that focus is there from the EU data protection authorities, particularly looking at behavioral advertising on social media, and also looking at issues about also the pay or consent model that we see ongoing on the Meta case as well. And the ICO has recently launched a consultation on that as well. So that's another important area that got traditional elements, but it's continuing to evolve into the new digital business models of social media companies as well, etc. The next area to mention is international transfers and data sharing. This has obviously been again an important area over the last few years, particularly after the Schrems II judgment. But I think what we have seen is a slight dialing down in terms of the activity of data protection authorities in this area, particularly in relation to data transfers to the US, because obviously we have the EU-US data privacy framework in place, and the UK has the data bridge in place with the US as well. So I think that has dialed back some levels of interest in that, but obviously it's still, I think, a constant compliance activity for organizations. And the EU DPAs in particular still obviously have a strong emphasis on the importance of undertaking transfer impact assessments. So organizations should continue to keep a focus on this particular area in terms of how it develops. I think one of the interesting areas to note, but we haven't seen a focus on yet, is data transfers to more questionable regimes. So data transfers to countries such as China and Russia, and whether those are going to come onto the radar of data protection authorities over the next year or so, because I think that may be a bit of an elephant in the room. We're not quite sure yet as to how data protection authorities particularly may sort of proactively reach out and start to look at those issues, given the focus they placed on the US in the past. I think that's an interesting area to note, where obviously in a way that the risk to data subjects' personal data could obviously be significant in those regimes as well. I think the last thing to note on international transfers is also to flag that from my experience at the ICO as well, often it may not be the starting point of an investigation as to how it comes to the attention of a data protection authority. So certainly at the ICO, sometimes we'll be asking a whole host of questions about an organization's data processing. And then as part of those overarching questions, issues come out of the woodwork about international transfers. So I think it's important not to be complacent, because often it can come out of an overarching audit or a wide range of questions about particular processing, which may not at the start be the central question, but obviously then it could expose an issue. It could also expose issues in relation to cyber breaches as well. And that was certainly the case in the Equifax investigation that the ICO undertook about 5 years ago, for example. To move through the list quickly now as well, we've got children and vulnerable groups there at the bottom. That's obviously an emerging area. I think it's very important to note, the significant risks and harms that could fall to different groups in society in terms of how their personal data is used. And obviously the work which has been done by the ICO in terms of the age appropriate design code is still a very high level and significant priority for the ICO. It's worth noting as well that the EU data protection authorities are following suit. So you now got a children's data protection strategy being developed by the AAPD in Spain. The KEYNOTE in France are focused on these issues as well. So all the big data protection authorities in the EU are now focused on this issue. And of course, you have the intersection with the Online Safety Act in the UK and the Digital Services Act in the EU as well. And I think it's interesting to note as well that there will be an age-appropriate design code coming from the EU soon as well. That will be linked to the Digital Services Act rather than the GDPR, but I think it will play an important part in this wider landscape relating to children as well. Then to move on to employment and HR, this is an ongoing, I think, a growing area of interest for Data Protection Authority. It's a particularly important area often where you can have the imbalance of power between employees and employers, and the challenges of using consent and ensuring there is an effective assessment of risks, particularly with the deployment of new technologies. So we've also seen significant enforcement actions in terms of the action taken by the CNIL against Amazon France. That was 32 million euros about workplace surveillance. We had the ICO's enforcement notice against Serco for their use of facial recognition technology, allowing for employees to check in and check out of their workplace. The ICO as well has prioritized AI and recruitment as well as an area for monitoring under their audit program. So you can see a whole host of examples that are starting to emerge under employment and HR. And I think also sort of projecting ahead a little bit as well, thinking about the likelihood of there being a Labour government in the next month as well. We also can see from some of the statements they're making that there's probably going to be an increased focus on employment rights as well, with a new employment regulator being mooted by the Labour Party as well. So I think planning ahead as well, that could be an important area. Then just to finish off, two areas. So information security is obviously still a constant. It's it's a bedrock of one of the set of principles in the GDPR, and we've obviously got ongoing risks relating to ransomware. We've seen numerous examples of breaches in the UK and in the EU, and the data protection authorities issuing sanctions in those cases, and of course the wider impacts that those ransomware attacks have on those businesses. It's also worth, I think, looking ahead as well for, I think, the nature of certain ransomware attacks as well being quite widespread, in terms of there being one service provider who's hit, who were acting maybe as a processor and then hit multiple controllers. So if we think about the breach involving Capita last year, for example, they were providing pension services to a whole range of organizations, over 100 organizations affected. And the ICO is yet to conclude its investigation in that case. I think there's an important trend as well, looking at what sanctions might be placed on processors rather than just controllers in relation to information security breaches. And I think it's worth reminding as well that we're talking about information security in the round here, not just cyber breaches and ransomware. We're also talking about those human error breaches, which continue to feature in the ICO's data breach reporting. And we've seen the ICO take enforcement action against the Police Service of Northern Ireland for a Freedom of Information Act, accidental disclosure of staff data, which was very serious. The MOD was fined in terms of how it had accidentally disclosed information about vulnerable people relating to Afghanistan. And there was a recent case involving the YMCA as well in terms of inadvertent disclosure of very sensitive data as well. So we can see a whole host of issues keeping information security on the agenda. And then lastly as well, to finish off, obviously the growing area of AI and automated decision making. And obviously it's still fairly early to say exactly how data protection authorities are going to enforce against AI, but we can see they're gearing up for it. And they're obviously starting to focus particularly on developers of AI systems, particularly the initial focus there on companies such as OpenAI, Meta and Google. And also they're starting to think as well about how they will start to develop their approach, particularly obviously in the EU in conjunction with the EU AI Act. And a number of the data protection authorities in the EU will obviously be given those functions under the AI Act as well. So we know this is going to be an emerging area, and that ultimately as well, it's going to get a lot more complex than just focusing on those big companies, because you've got a whole supply chain relating to the AI lifecycle in terms of companies whose data may be fed in and may be used as part of the AI training process. You've got developers of AI systems, you've got deployers of AI systems that may be enhancing those developed systems with their own training data. And you've obviously got a whole range of players in that space as well, including cloud software providers who are providing the infrastructure as well. So I think you're going to start to see the data protection authorities, systematically focus on the areas of greatest risk in terms of how that develops as a key theme over the next few years. And lastly, as well, I think to flag the importance of automated decision making, this is definitely going to come up the priority list of data protection authorities over the next few years as well, as organizations really seek to utilize AI, particularly as well, going back to my example of employment and HR as well. We know there will be a big focus, particularly about use of AI and in hiring decisions as well. So I'm going to finish there and just talk briefly about global trends, because I know we need to get on to our discussion. Just to highlight as well, but it's worth monitoring, whatever scope of your organization's operations, that you learn about the trends in different regions of the world, depending on which jurisdiction you're caught by. So obviously we talked a lot about the UK and EU already. It's worth noting that, developments in the US at the moment. So there's a proposed American Privacy Rights Act, which is currently being considered in Congress at the moment, and new state laws being passed. So it's important to monitor developments there, and including the actions taken by the Federal Trade Commission as well, who are still a very active privacy regulator, and also the growth of laws in South America as well. So Brazil now has a large established data protection authority, which has been set up over the last few years as well. And to note, in Asia as well, there's a significant growth of new data protection laws there. And the regulators in Korea and Japan have now got new fining powers, and are also focusing on issues like automated decision making and AI as well. And then lastly, to highlight as well the importance of considering developments in Africa and the Middle East if you're operating in those jurisdictions. Large numbers of new laws have been passed in Africa now. There are active regulators there as well. For example, in Kenya, who've recently taken enforcement action on a range of different issues relating to cryptocurrencies. And there are, a number of new regulators establishing themselves in the Middle East as well. So just to finish off, to note really the full span of global trends that we're seeing now. And I'll hand back and we should perhaps start our conversation.
Okay, thank you, Steve. And we had a lot of questions come in advance of this presentation. So there is still time if you want to use the chat box to send questions in as we go through. But I'm going to turn first to Eleanor. We had a question that said, following the demise of the Data Protection and Digital Information Bill, what's the UK approach likely to be post the election?
Thanks very much, Robert. Yes, I think it was quite a surprise to have the election called when it was, and perhaps even more of a surprise that bill, which we'd all been looking at for the last few years, really, under Boris Johnson, under Liz Truss, and then under Rishi Sunak in various forms, suddenly just disappeared. And I think that's possibly a sign, because in this wash-up period, when a general election is called, there's a very short amount of time to put some bills through, some legislation through, and actually the opposition is very powerful, because if they don't like the bill, they'll just say, no, that's not going through. And that's exactly what happened. The Labour Party said, no, we're not having the Data Protection and Digital Information Bill. Why was that? I think there was a sense possibly that some of the areas were a bit controversial, a lot of it wasn't, and perhaps that having a more or less the same regime in the UK and the EU is actually quite good for trade. We see a huge push in the manifesto on growth and that sort of thing. So it may well be that there's a sense that actually everyone's quite used to this regime now. It doesn't create a barrier to trade with the EU, and so we should simply continue with the UK GDPR as it is. Having said that, I think possibly we might see some of the provisions come back, particularly on things like digital identity and that sort of thing, possibly tacked on to, and we've seen the manifesto, of course, there is going to be an AI bill. So we may see some pretty uncontroversial elements, I would say, of that bill perhaps re-emerging in the future under a future Labour government, as I think the polls are suggesting is pretty much an inevitability at this stage. So I think most of what we saw in the Data Protection and Digital Information Bill probably will not survive. So a few elements, but I think that era of wanting to change our data protection frameworks is possibly over.
Okay, thank you. And Simon, what are your thoughts?
Yeah, thank you very much. And thanks very much, Steve, for your presentation and for the answer that you've just given us, Eleanor. I think, yeah, I tend to think very much the same, that I think a lot of the provisions that were in the Data Protection Digital Information Bill, we've probably now seen the last of, but there'll be certain ones that might raise their head again. I think we should also be mindful that there is a planned review of adequacy next year. In fact, the period actually is due for expiry next year, so there'll be a negotiation, there'll be a review process that takes place. So that might be something that might be in the minds of the new government, assuming there is a new government. I don't know, of course, but from that point of view, and also there'll be, I think, a question about how much alignment the UK will want to have with Europe. I think, much as you said, because obviously in the past they've been looking for more of a divergence, from the EU position in developing a UK-specific law that's set in a different place really to EU law. But I think now that there might be a move backwards the other way, potentially to want to have slightly greater consistency between the UK and the EU, in which case that might move us to a different place. I think it's also going to be interesting to see where we go with our AI particularly, and whether we'll want to follow a similar model for AI and where that's going to sit as well, whether that is going to sit within a privacy space or outside of that. But obviously there'll be a lot of overlap in the area of data protection and privacy, and particularly whether there'll be a desire to particularly apply more regulatory framework over large language models.
Yeah, and Steve, your thoughts?
Yeah, I think very much agree with what Simon and Eleanor have said about the prospects for the DPDI bill. I think as well it's worth reflecting, I think, on a number of conversations I had with multinational companies over the last year who just couldn't really, I guess, understand the need for some of the changes in the Data Protection and Digital Information Bill in terms of some of the changes to governance, whilst they could see them as, I think, interesting and innovative ideas to evolve tools such as data protection impact assessments into a different form of risk assessments and moving away from the data protection officer model. I think for multinational companies who have sort of a global approach to governance, which is largely geared on GDPR, they were still really focused on probably keeping an overall standard based on that. Therefore, they wouldn't necessarily be able to sort of avail themselves and take advantage of a number of the opportunities that the government was selling in terms of how the bill could help companies. So I think some of those areas sort of go back into the reflection pot. Well, so I think there's some useful ideas in the bill and some sensible things about trying to move to a more balanced and proportionate regime for cookies and soft opt-in for charities and some other areas, etc. I think overall, as Eleanor said, I think the focus will more be on AI with the Labour government. And I think just to recap on something I mentioned earlier about Labour's focused on employment rights, there was also an AI bill that's been proposed by the TUC, the Trade Union Congress, which was actually published a while ago. And I could imagine as well there might be a significant focus on particularly strengthening AI rights in the workplace and a potential Labour government in future.
Okay, excellent. And I'm just going to stick with you, Steve, for another question we had, which is what aspects of data privacy governance can be transposed to AI governance, as both of them seem to overlap? What can we use for AI risk that we're already using for data protection, for example?
Yeah, I mean, I think there's a really strong crossover between the two, and to use the word synergy, I think there's really good opportunities for data protection professionals in organizations to be at the heart of the conversations about what good AI governance looks like. I think the experience that data protection professionals have developed in working up policies and procedures for DPIAs, their experience as well in understanding the life cycle of data, from collection right through to retention and issues like data minimization. I think they also play into other questions about AI as well in terms of data quality. And organizations are going to need to think about data quality for a whole host of reasons, not just with GDPR and data protection laws globally, but also, data quality is going to be at the heart of the trust and confidence in how different AI tools work. And we're not just talking about generative AI here, but across a whole host of different types of AI applications, which could involve machine learning as well. So I think that the importance of data quality will also be a really important way that data protection governance can overlap. Clearly, ultimately as well, though, there will be wider issues to consider, in terms of the regulation of AI, like intellectual property, wider risks relating to commercial information, also how organizations, are setting up contracts, etc. And also, I think, thinking about, wider risks and harms, not just to individuals, but also to groups in society. And, wider risks and challenges may sometimes sort of fall outside the data protection space. There is a really strong case for the intersection. And we can see that already. I mean, I'm sure lots of people are already looking at these different courses and offerings from the data protection sector, which are already focused on AI in terms of the IPP's new AI governance certificate as well. So we can certainly see the links there.
Okay, then Eleanor, what are your thoughts on the intersection with data protection and AI management?
I mean, as Steve has said, that there is a really strong crossover and synergy. I do think, though, that there are perhaps some slightly different skill sets that one might need in unpacking exactly how these technologies are going to affect individuals and explaining how they work. And what we found is that you really need a multidisciplinary team often. You need your technology experts, not only to develop perhaps the systems, but to explain how they actually function. And it's a bit of translation, I think, that's required in order to turn this very sophisticated technology into something that people can really understand, and that the data protection professionals can actually do their risk assessments properly, really understanding what the risks are. So it's quite time consuming, I would say. Sometimes with something more simple, we're all used to doing a data protection impact assessment, but this can require quite a sort of careful and iterative dialogue, I think, between all the professionals, so that everyone, the lawyers, the IT professionals, the IT governance professionals, everyone together really understands what risks and mitigations exist in this particular context.
Thank you. And picking up on that word risk, there's a question here which I'm going to get Simon to answer. How does a small singular privacy team prioritize risk management against all the other day-to-day work? How do we articulate this as a real tangible risk to executives? Simon.
I think that's a great question. Thanks. So I think it's really about having a good understanding of the way that your organization is working in terms of collecting data, how it's using it, where it's being stored, just having a good visibility, I think, which obviously requires strong stakeholder relationships with all the key people, with the technology team, with operations, with marketing, with HR, all of the other kind of business functions. So to get a good grip on understanding the data and how it's being used. Once you've got that, which obviously in a GDPR form is putting that into a record of processing activity or some kind of documentation so that you can understand that and make sure that all of that processing is lawful. But in doing that, you're going to identify where your risks lie and help you to prioritize. I think that's a really good exercise in doing that. Will help you to identify, well, where might we have a higher level risk? Where might we have lower level risks? So that it will help you to prioritize. And I think Steve's obviously given us a really good heads up on what the regulators are looking for today and what kind of different lenses you could have on what those risks might look like and how you might tackle them. But I guess recognizing that organizations, we do, particularly smaller organizations, we don't have infinite resources. So from that point of view, it's a matter of being pragmatic and to be able to tackle what you perceive as the biggest risk and making sure that you can evidence that as well. I think that's a key thing, is making sure that you meet Steve talked about accountability. I second that very much. Just make sure that you're keeping the documentation, that you're keeping copies of your assessments and things like that. Even if they're verbal discussions, make sure that you've recorded the decision that you've made from that point of view. So it's not necessarily about having to do absolutely everything if you have a small team, but making sure that you can evidence why you've prioritized things over others and having that, keeping that evidence of it.
Now, we had another question on risk management, but at the other end of the scale. So, Eleanor, what tips do you have for organizations that operate globally across multiple jurisdictions for managing data risk?
I do think it's becoming more difficult. Steve's slide of all the different sort of regions of the world, there's more and more data protection law coming in. It doesn't necessarily all fit together. And I think one of the problems that large multinationals have is the sort of contradictions and having to look at, okay, in this context, I'll have to comply with one regime or the other. And the thing that tends to happen is that whatever regime has the highest standard wins out as the sort of global standard, and that tends to be GDPR. But then you have to nuance that in particular jurisdictions in order to ensure that you're compliant within that particular jurisdiction. And I think, even within the EU, GDPR was sold as something that was going to create uniformity across the EU in order to enable free flow of data and that sort of thing. And actually, that isn't what we're seeing at all. I think we're seeing regulators taking different approaches to different things. I mean, there are, I think, something like 90 references actually to national law in the GDPR in itself. So that's both the recitals and the operative text. But that just shows how much scope there is for the obligations to be varied, for exemptions, depending on what jurisdiction you're in. So unfortunately, although you can take a GDPR approach, even within the EU, you are going to have to get local counsel advice, I think, on many projects in order to ensure that you are compliant with your specific activity that you're planning.
Although I would add that I think the return on investment for all the GDPR pain is that some of those other countries that Steve mentioned are heavily influenced by GDPR. And that does, I agree with you, Eleanor, you would still need to localize what you do. But if you've got a good range of policies and procedures, it's not that hard to work on those for other parts of the world, whether it's the UAE or Brazil or whatever. So, Steve, I'd ask you to jump in on that.
Yeah, I think it's a really important question. I think sort of echoes some of what Eleanor said, that working with multinational companies, I think you still often come across these sort of local issues. Even though there's been this convergence on GDPR, there's still that challenge sometimes. But I think the convergence on certain areas is helpful in terms of being able to look at certain issues which are probably going to be common across most jurisdictions. So I think even some of the issues about AI, whilst you may need to look at some local issues, questions about fairness and bias, in terms of actually having a process for assessing fairness and bias, even if you may need to look at some particular issues in local jurisdictions, it's going to be inefficient as well to have 40 different approaches to that. So I think the role of a global governance framework within the multinational, which provides the core framework of policies and procedures which act as the spine, and so the organization tries to standard, for example, its approach to bias as much as possible, and then empower and train people in local regions to be able to adapt or deploy or develop localized procedures. I think that's what we're seeing now. But I think the importance of the centralized function and the globalized privacy management program of sort of setting the standards for the organization, which obviously will sometimes need to go to the highest standard, so it's heavily influenced by GDPR. I think that's going to be really important, but it's not to say for organizations it's not taking a lot of resource, and these teams across the whole horizontal range of issues that data protection flows up, in these multinational companies, they're large teams.
Good. We've had a question in, and it's, do privacy policies have to be updated to include notice that AI processing is taking place? How granular do we have to be? Simon?
I'd say so. Yeah, I think we need to be clear how we're using people's data. So from that point of view, if we're using automated technologies, we need to be clear on that, and particularly where there's things like profiling, which again may well happen within AI models, will do in most cases, and particularly where there's any automated decision making taking place. As well as one of the things in privacy policies, privacy notices, we need to be clear on is when we're relying on legitimate interests as our basis for processing, and that's something that often happens within an NLI model. So those are kind of my thoughts. Yes, we need to make the effort to be clear, and I think Eleanor and Steve have both touched on the topic of how do you explain your AI processing. Well, your privacy policy is really at the sharp end of that. How do we make it clear to people what we're doing, and put that into nice, simple language for people so that it's not too scary and that it's understandable. So yeah, I think that's the challenge.
Changing tack here, there was a question which, Eleanor, I'm going to ask you to respond to. How significant is the recent Harrison versus Cameron case for organizations handling DSARs?
I think it is quite significant, actually. So for those of you who don't know about the facts, this was essentially a commercial relationship that went wrong, and there were some rather heated phone calls between the parties, and some of the phone calls were recorded, and there were threats of violence made by one party to the other, and the recordings were shared by the individual who received the call with 15 other people, and they comprised friends, family, and also the employees of the individual concerned. And I think the sort of real takeaway for me for this case is about to what extent would you need to actually reveal the identities of those individuals. In this case, the identities were withheld, but the question was, what is the obligation under Article 15? Do we have to? Because the legislation says, it talks about the recipients of the data or the categories of the recipients. So the question was, do we need to actually say who these 15 people are? Or can we just say, they fall within those categories that I've just mentioned, family, employees, and that sort of thing. And the court looks at the right of subject access through the lens, really, of it being a gateway to exercise other rights. And some of the rights, of course, the right to rectification, the right to deletion, require the controller to go out to the recipients and say, can you rectify, can you delete this data? And Article 19 of the UK GDPR does say specifically that the data subject should be able to know who has received the data in order to be able to effectively exercise that right. So the court said, on the sort of face of it, you need to tell the data subject or the requester of who's made the data subject access request who has received their data. But, and there's a big but here, so before you sort of go and list absolutely everyone in your responses who's received the data, you need to think about two aspects, really. Firstly, it might actually be impossible to do that because it would require a disproportionate effort. So you need to think about the proportionality, and could you rely on that exemption to say there are so many recipients here that we're going to have to tell you just the categories because it's just not possible to go into that much detail and tell you exactly who they are. or potentially, and I think this is going to be a really important one, that you apply the exemption under Schedule 2, paragraph 16, to do with the protection of the rights of others. So in this case, actually, the court found it was correct to apply that exemption and not to explain exactly who had received the data because of these threats and the sort of rather nasty context here. But it may well be that you could say, in terms of specific recipients, that you feel actually that their privacy rights, those recipients' privacy rights, outweigh the rights of the data subject to know their identities. But we're going to have to do a bit more work on that, I think, to think about, where does the balance lie here, and whose rights win out, and is it the recipients to their privacy, or is it the data subject, the requester under the data subject access request, who wants to know who's received their data? So I think it is, as I say, quite a significant case.
Robert, I think you're on mute.
Sorry. You just used the phrase, Eleanor, about balancing. And we've got another question. It's probably going to be the last one. We were hoping that the bill might have brought about a lightening of the DPIA and LIA obligations. Do we think there will be a more pro-business, lighter touch approach post the election? I'll start with you, Steve. What do you think? Should we have a lighter approach to LIAs and DPIAs?
Yeah, I think reflecting on what I said earlier as well about the situation in terms of the fact that many companies are already complying with GDPR in the EU, I think it's quite challenging to want to think about a different process for the UK compared to the EU if you're operating in that context. But I think particularly for public authorities or for smaller business in the UK, there still could be perhaps an opportunity to think about how we can ensure that these processes, compliance processes, can be implemented in a proportionate and an effective way. So I think it's a subject that will probably come back up if a new government comes in, whether that's Labour or Conservative, because both are focused on growth and supporting businesses. But I think it's finding the right route and mechanism to do that works for the whole sort of range and spectrum of companies that we have covered by GDPR at the moment. I also had some concerns about the changes that the government proposed in terms of having recognised legitimate interests on the face of the law, in terms of having some of those set categories relating to quite broad areas in the public sector at the moment, such as protecting children, etc., in a public sector context. In terms of whether those were very, very broad categories that really just actually therefore sort of reduced the need to consider necessity and proportionality properly in certain scenarios in relation to processing data as well. So I think it's about finding the right balance. So I suspect that these issues may come up again, but I think what we got to do is take these things back to the core principles. Why are they important, and how can organizations actually use them to really protect their customers or their citizens from harm, in terms of how they're processing the data, in terms of DPIAs leading to practical, meaningful steps in terms of protecting individuals rather than a box ticking exercise. And I think that's why there was some attraction in a risk assessment proposal in the DPDI, moving to that from DPIAs. But I think the DPIA concept is heavily ingrained, so some companies probably don't want to move away from it.
Yeah, agree. And Eleanor, any thoughts on this question?
Yeah, you do only have to do the DPIA if it's high risk processing. And I think it can be such a useful tool, actually, just to make sure that your processes work properly to protect your customers and the individuals whose data you're processing. And actually, that's a big part nowadays, I think, of people's offering, and if you don't get it right, a bit of a reputational risk. So in a way, it's an investment, I think, in your processes, and can be very useful. And I think the thing that we really need to think about is that ultimately we're balancing the rights of the individual against the rights of the organisation to conduct whatever activities it needs to. And where we've got sort of quite low risk data, we don't need to be so worried. And yes, we might want to record that we've done a legitimate interest assessment, but it doesn't need to be terribly long, because there's an obvious legitimate interest in doing what we're doing. And conversely, as Steve was saying, these box ticking exercise, sometimes you see that in relation to something which actually is quite intrusive. So I think it's just about getting comfortable with gauging what the risk is. And we're all still perhaps learning that. But I think as we get better at that, it should be something that we can do in a way which is proportionate and doesn't take up too much time where it doesn't need to, but where we think really carefully about the risks when there are significant risks to individuals.
Yeah. And anything to add quickly, Simon?
I think you summed it up nicely, but the one thing I would just add is that you don't have to use the specific templates that have been published by regulators, which actually I find a little bit wordy, and they're actually designed for privacy professionals to understand. And yet, actually, we want our colleagues to fully understand the information that we're asking for across the business. So from that point of view, I'm a bit of an advocate in kind of tailoring, let's say, the assessment form so that people can understand it properly, the information that you're requesting, and what the benefit of providing that information is. Because I often see DPIAs that are quite badly filled in because people haven't understood the question that you're asking or where to put it in. So I think there's more process things that can be done in some organisations to kind of improve on that process and to help people go through these assessments.
Yeah, I recently, in an organisation I was helping, heard somebody describing these complex DPIAs as being inappropriate for some parts of the business, and could we not write these in rage-appropriate language? So we've got 3 minutes or so left. So in closing, Eleanor, do you want to, any final thoughts?
I think it goes back, as Steve was talking about at the beginning, to that accountability piece and just making sure that you have carefully documented what you're doing with your data. There's an awful lot going on. We're all deluged with information about this, but I think that's the absolute core. If you can feel comfortable that you have thought carefully and you've recorded what you're doing, you should be all right.
Wonderful. Steve?
Yeah, I think I would echo that point as well. In terms of obviously what I set out in the opening part of the presentation, there's a lot of different issues. Even looking on LinkedIn at the moment, there's a huge amount of noise about different things you potentially have to pay attention to. But obviously it's filtering it down and working out what's really relevant to you in your context, in your organization, with your risks, with your customers, and the particular sector and the particular supply chains you're involved in. And then, taking out some of the noise and then really, focusing down on what you really need to spend your time and effort on to make sure you're providing that best level of compliance that you can for your organization.
Okay. And Simon, final thoughts, and I'll leave it to you to close.
I'd just like to do some thank yous, if that's okay. Steve, thank you very much for joining us in your presentation today and the wise words that you've put forward. I think that's been very insightful for people. Eleanor, great. Thanks so much for all your comments and thoughts on this too. It's been brilliant. Robert, again, for hosting so well for us. Thanks very much for that. And I hope you've all found it useful as an audience. I hope you've all picked up some useful kind of tidbits and knowledge and things like that. Because I think there's been some great stuff that's come out today. So just a quick reminder that obviously we've been recording this. It will be published on our website tomorrow. And for you that have signed up for this, you'll get an email about this time, around about 3 o'clock tomorrow, with a link to the recording. So thanks so much, everyone, for joining us. Hope you've enjoyed it, and we'll leave it there. Say goodbye. Okay, take care.
Bye.
Bye.
Thank you. Bye.